Hi, this is Justin Caplin, and this video is about child protective orders in Utah, and specifically down in the St. George area. Um, so when you're trying to protect your child from abuse or neglect, you've probably heard about the option of a child protective order. So this video will be an overview of the child protective order process. But if you're interested in getting into more specifics on filling out the paperwork or proceeding or defending against a child protective order, I'm recording separate videos for each of those. So what is a child protective order? A child protective order, or CPO, is an urgent and usually short-term order that can be requested through the juvenile court in the state of Utah to try and get some immediate protection and orders for a child who is being abused, or in some situations, a child who has been abused in the past. It's important to know what a child protective order is really for, as they are often misused or misunderstood. And that can lead to some frustration, wasted time, and wasted expense. So looking at the Utah code, because that's what will govern, we'll read what a child protective order is intended to address, and we'll look at some definitions that the judges are familiar with, but that you'll need to understand in order to see if a child protective order is right for your situation or for your child's situation. So looking at the child protective order code, so Utah code 78B7, if we look at section 202, then that addresses child protective orders and filing one. So in subpart 1, it says, any interested person may file a petition for protective order, 1, on behalf of a child who is being abused or is in imminent danger of being abused by any individual, or 2, on behalf of a child who has been abused by an individual who is not the child's parent, step-parent, guardian, or custodian. So kind of the difference there is if it's going to be filing it against a parent, step-parent, guardian, or custodian, then it's that first part that is being abused or is in imminent danger of being abused. If it's not somebody that fits that category, then it could be a single occurrence of abuse or abuse from the past. So you'll see that same standard in the section that addresses what a judge must consider whether to actually grant it. So in section 203, subpart 5, it says the court shall issue a child protective order if the court determines, based on a preponderance of the evidence, that for petition, well, basically that for anybody, if the child is being abused or is in imminent danger of being abused, or for the part that says only against people who aren't a parent, step-parent, guardian, or custodian, then if the child has been abused and the child protective order is necessary to protect the child. So there you see that the judge, obviously, the reasons you can file one is the same reasons why the judge can issue one. But what does abuse mean? So we hop over to section 201, the definitions to see that. Pretty limited. It's very specific. And specifically, as used in this chapter, abuse means physical abuse, sexual abuse, any sexual offense described in Title 76, 5B2, sexual exploitation, or human trafficking of a child for sexual exploitation under that code section. So typically, this is for physical abuse or sexual abuse of a child. So emotional abuse or other potential harm to a child, that's not what this is for. That's not what child abuse, it's not what a child protective order is for. Now, to specifically find what sexual abuse or physical abuse means, then you have to look over at the Juvenile Court Code in section 80. Sexual abuse is defined as an act or attempted act of sexual intercourse, sodomy, incest, or molestation by an adult directed towards a child. An act or attempted act of sexual intercourse, sodomy, incest, or molestation committed by a child towards another child with certain contingencies. Engaging in any conduct with a child that would constitute an offense under any of the following. So Title 76, Chapter 5, Part 4, sexual offenses. So there's a list of them there. Child bigamy, incest, lewdness, sexual battery, lewdness involving a child, voyeurism. So sexual abuse is specifically defined. There's a lot of things that constitute that, but it does have to fall under there for it to qualify. And then physical abuse means abuse that results in physical injury or damage to a child. If you want to look at abuse itself, so what does that mean? So abuse that results in physical injury or damage to a child. So abuse means non-accidental harm of a child, threatened harm of a child, sexual exploitation, sexual abuse, or human trafficking. That a child's natural parent intentionally, knowingly, or recklessly causes the death of another parent of the child. There's a few other things in here that can be constituted, but they're obviously pretty rare. It doesn't include reasonable discipline or management of the child, including withholding privileges. So that's all set forth there in the code. So a child protective order is specifically limited to cases of physical and sexual abuse, not cases for drug use, alcoholism, or even neglect. It is specifically just abuse. So the process for obtaining a child protective order, first you're required to make a referral to DCFS. They'll give you a referral number and at some point begin an investigation. After reporting, you can file the petition for child protective order with the juvenile court in the district that you live or that the child's at. From there, the clerk gets it and gets it to the judge. The judge looks at it as soon as possible. The judge will review the petition and take the information or allegations as true. They'll just assume that the information is true and will determine based on that if true, does it meet the requirements of physical or sexual abuse? Does it meet those definitions and those provisions in the statute? If not, then the judge will deny the child protective order. And if so, the judge will grant a temporary child protective order and then decide what protections to enter in that temporary order. He won't automatically grant everything that's requested. He'll also appoint a guardian ad litem, which is an attorney employed by the state to represent the children. And as part of the process, the guardian ad litem will meet with the child or children, perform their own investigation of sorts, and ultimately make recommendations and argument on behalf of the children. A hearing will be set. Typically down here in southern Utah, it'll be an initial appearance, kind of a pre-trial. And then the temporary child protective order will be served by the sheriff on the respondent. The initial appearance hearing, the judge will usually discuss with the attorneys and parties where things are at and inquire what direction the case will need to go. Sometimes they may ask of mediation, and this is something pretty unique to down here. The judge will ask if mediation may be helpful. The juvenile court has its own mediation program. You don't have to pay for the mediator. It's set for just a couple of hours at a time with the state juvenile court mediator. And it takes place there at the court usually. In a protective order case, a judge cannot require or order mediation, but if the parties see a benefit and agree, then the judge down here will usually have that scheduled and you can participate in that. If the parties elect not to do mediation, or if they do mediation but it's unsuccessful, then the next step is to have an evidentiary hearing. That's a hearing where the evidence is presented. And it's essentially a trial where the petitioner must prove with evidence that the child is being abused or is in imminent danger of being abused or was abused by someone not a parent, step-parent, or guardian. Witnesses are called, questioned, cross-examined. Other evidence is presented. The child may be a witness. That happens more often in juvenile court. There's certain specific rules to juvenile court. We won't get into those in here, but witnesses called, evidence presented. The guardian ad litem will participate in the questioning, will argue and recommend on behalf of the children one way or the other. And after that's all concluded, then the judge will make a decision either to enter or deny and dismiss the child protective order. So a few things to be aware of. If the judge grants the child protective order against a parent, step-parent, guardian, or custodian, then the order typically lasts only 150 days. If it's against someone other than those people, then it expires when the child turns 18. So be aware of that, depending on who you're filing that against, how long that's going to last. Since most child protective orders are against a parent or step-parent, it's intended only as a stopgap measure to get a fairly quick order in place and then give you, a period of time to get a more permanent or long-term order through the district court in the custody or divorce action that has the ongoing jurisdiction between those parents and those children. The last thing I want to mention in this video is just how most cases resolve, at least at least down here in St. George. The majority of child protective orders do not go to an evidentiary hearing. Most of them are resolved by an agreement. So a few common resolutions are an agreement to address the protections in the district court, an agreement to transfer the case from juvenile court to the district court judge that's assigned to the custody or divorce case, and then proceed with the child protective order there. An agreement to dismiss the child protective order case, sometimes with, sometimes without other parameters. Often it might be one to dismiss the child protective order, but roll protections into a temporary order in the district court case. That's pretty common. Or an agreement to have the child protective order enter without a finding of any wrongdoing, so without having to prove the evidence and have a decision made against the respondent. Sometimes there will be an agreement to do that, and to just have it enter. So if you're considering a child protective order, just make sure you understand its purpose as well as its limitations. Make sure your attorney helps you understand both sides and the reality of what will be the best impact or have the best impact and effect for your children, both in the short term as well as the long term. If you've got any questions, you can feel free to contact us.